Hello, and welcome to our bite-sized series on the EU Data Act. So far in our series, we've covered an overview and a purpose of the Act. Our second video was on the data access and sharing obligations, and today we're going to talk about the cloud switching rules. So I am joined by my colleague Shay Buckley on our Tech and Innovation group. So Shay, could you just provide us a brief summary of what those cloud switching rules are?
Sure, hi Ciara. So as you've already discussed in the first two videos of the series, the Data Act is about increasing competition and reducing friction in the digital economy. For cloud computing services in particular, the EU wanted to combat supplier lock-in. To do this, the Data Act introduces a prohibition on any restrictions or obstacles on a customer when they're seeking to move from one provider to another provider. The providers are also under a proactive obligation to facilitate that switching process.
Okay, and so who are we talking about here when we're talking about cloud providers?
So the Act actually refers to this cohort of services as data processing services, but essentially, yes, we're talking about cloud computing services. Cloud computing services are any digital service where data is processed and stored remotely and where customer use is elastic in that space is provisioned based on demand. The definition encompasses the three main categories of cloud computing services that we usually think of. The first being infrastructure as a service, such as cloud storage services or rented servers. The second being platform as a service, which is any digital service where a customer can deploy an application without the need to maintain or provision or manage the infrastructure. And software as a service, which is any cloud-based application which is ready for the end user.
How does this concept of data processing service or cloud provider relate to the concept of a related service, which has to do with the connected products and therefore the data access and sharing obligations we talked about in the second video?
Yeah, so they're different definitions, but there's definitely overlap there. For example, a SaaS provider might be providing a related service with respect to a certain connected product and would therefore need to comply with the data sharing and data access rules. But that SaaS provider is also likely to be considered a data processing service and would therefore need to facilitate switching.
And what exactly are the cloud providers prevented or prohibited from doing?
The providers need to facilitate switching. So essentially, they can't inhibit the customer from terminating the contract and moving to a new provider. And in addition to that, the providers can't prevent the customer from unbundling services.
Okay, and do they have to, or how do they have to facilitate or actively facilitate switching?
To facilitate the switching, the provider will need to port the customer's exportable data and any digital assets on the customer's request to either a new cloud service provider or to on-premises infrastructure. The process can take no longer than 30 days unless the provider notifies the customer that it is not possible to complete that switching process within the 30 days, in which case the period can be extended by up to 7 months. For platform as a service and software as a service providers, they also have to make available open interfaces. These have to be made available free of charge to customers and to subsequent providers. The interfaces need to have sufficient information in order to allow the development of software which can communicate with the service for the purpose of data portability and interoperability.
So they have to facilitate switching, and the SaaS providers and platform as a service providers have to publish these open specifications. But is there a requirement to have functional equivalence between the old and new system?
So that obligation only applies to the infrastructure cloud providers. For those providers, they need to facilitate functional equivalence. In other words, where there are shared features between the new service and the old service, the new service needs to be able to produce materially comparable outcomes when the same inputs are put into it.
Okay, so the functional equivalence is only in relation to cloud storage providers. It does seem that this switching process obviously involves the original provider, the customer, and the new provider. So is the new provider as well under a duty to participate?
Yeah, so all parties involved in the switching process under the Data Act are under an obligation to cooperate in good faith to facilitate that switching and also to maintain continuity of service for the customer.
Okay. And I've certainly heard about the elimination of switching charges. What is the timeline in relation to that?
So switching charges will be entirely prohibited from the 12th of January 2027. From the 11th of January 2024 to the 12th of January 2027, switching charges can be imposed, but these switching charges must be limited to those costs that are directly incurred by the provider. Just a small caveat on that, that the prohibition on switching charges does not apply where the customer requests a period of parallel use of services, because that requires a constant and continuous sharing of data between the services.
Okay, that makes sense. And I think the elimination of switching charges from the customer's perspective will certainly be a welcome change. Just on transparency, we talked about in the second video in relation to the data access and sharing obligations, there is a requirement on providers of connected products and related services to disclose information about the type of data that's processed and how that data can be accessed and shared. So the question is, are there equivalent transparency obligations in relation to the switching obligations?
Yeah, there are transparency obligations. The cloud service providers or the data processing services need to disclose the information on the procedure for that switching process. And they also need to make available a link to a register, which will contain information on data formats and data structures, as well as all relevant standards and any open interoperability specifications. Okay. Additionally, those providers need to make available information on the location or the jurisdiction where their ICT infrastructure is located and the measures that they are implementing in order to prevent unlawful government access to that data.
Okay, so changes will have to be to public information or notices. In relation to the contracts, again, in the second video in the data access and sharing obligations, we mentioned that there is a prohibition on unfair terms in a B2B context. Are there any contractual requirements in relation to the switching obligations?
The contracts between the provider and the customer need to be updated to align with the requirements of the Data Act. Importantly, the Data Act requires that the contract clearly states that the contract automatically terminates on the successful completion of the switching process.
Okay, I think that's going to be quite big for providers to consider what that means for them financially in terms of revenue recognition, for example. But thank you for taking us through that. That's incredibly helpful. And thank you to everyone for participating and listening to this series. We have 3 videos in the series that you might review, but thank you for your time.